Hi everyone, thanks for joining today. We're going to go ahead and get started. Thanks for taking time out of your day to join us. I'm Jenna Kirsten, your moderator for today's webinar. I'd like to welcome you to today's session on GDPR for the marketing industry. Just a few things before we dive into our discussion. All attendees will be muted throughout the session, but we do encourage you to ask questions using the Q&A feature, and I will monitor those throughout the hour, and hopefully we'll have some time reserved at the end to answer those. This session is also being recorded, and all attendees will receive a link to the recording as well as a copy of the slides in your inbox tomorrow. A little bit about KirkpatrickPrice. We are a licensed CPA firm providing assurance services to clients worldwide. Our firm has over 13 years of experience in information assurance by performing assessments, audits, and tests that strengthen information security and compliance controls. We offer information security services such as audits, pen testing, plus readiness and guidance on frameworks like SOC 1, SOC 2, PCI, HIPAA, HITRUST, and of course, GDPR. We also encourage you to connect with us by subscribing to our blog, visiting our library of recorded webinars, or following us on social media. You can find us on LinkedIn, Twitter, and Facebook. Now I'd like to welcome our speaker for today, Mark Heinley. You've probably heard him before if you've been on any of our other privacy webinars. Mark is the Director of Regulatory Compliance here at KirkpatrickPrice with over 12 years of experience in this arena. So welcome, Mark.
Thank you, Jenna, and thank you to the rest of you again for joining us today as we talk through some implications of GDPR for marketing activities. As always, we want to begin with our legal disclaimer to remind you that this presentation is provided for educational and informational purposes only, and it does not constitute legal advice or establish attorney-client relationships. So if you do need legal advice on GDPR and marketing or other privacy-related issues, please consult with your own attorney. Otherwise, we're happy to help, as we'll talk about at the end of our presentation today. So our agenda for today, we're gonna just ask and answer the question, why marketing? Why focus a year after the enforcement date of GDPR on an entire session on marketing? I think there's some really good reasons to talk about it, especially a year in, based on what supervisory authorities and industry sources are telling us about marketing activities. So we're gonna tell you why this is important, regardless of whether your core service is marketing or not. We're going to talk about the legal basis for processing when it comes to marketing. There's some dynamics that are particular to marketing that are going to come into play with legitimate interests that's probably more applicable or more challenging than any other processing activity. We're going to talk briefly about disclosures and rights because those are important topics, but they're pretty, our coverage is going to be pretty straightforward and enough to point you in the right direction. And then we're going to spend a little bit of time talking about some marketing developments a year in and some specific situations that you should be aware of when it comes to marketing that might create some challenges and maybe cause you to think through how you're handling those specific situations. And then we'll wrap it up at the end. And if we have enough time, we'll offer a Q&A for our participants. All right, so let's first talk about why we're having an entire webinar 1 year into GDPR enforcement on marketing. First, since we're a year in, we have a little bit of information about complaints and issues based on publications by the EU itself and then by supervisory authority and data protection authorities. And what we found from an infographic published by the European Commission back in January on Privacy Day is that most data subject complaints relate to marketing. So the number one issue that's causing friction among data subjects is marketing. That's one of the reasons we're talking about it today. Specifically, the infographic talked about or referenced telemarketing and promotional emails as the top two out of the top three sources of complaints. So one of the reasons that we're talking about this is because it seems like organizations are still struggling to understand how to market under GDPR regulatory scheme. Second, the unique nature of data subject rights related to direct marketing. So direct marketing is the only processing activity that specifically has a data subject right dedicated to it, that specifically and expressly addresses it. So, the sales of goods or services, or even social media, which, given all the challenges that Facebook and other social media sites and Google have had and are already subject to litigation and investigation and enforcement activity, there isn't a specific data subject right related to social media. The only processing activity that has a data subject right directly tied to it, and particularly cut and dry, is direct marketing. So that tells you that the crafters of this legislation indicated that there should be some particular focus on marketing people's personal data. Third, the legal basis for marketing creates a dynamic, an incentive and a challenge to understand when it's appropriate to use someone's personal data to market to them. This kind of gray area around legitimate interest, and even to some degree, we're going to talk about both consent and legitimate interest in a few minutes, but both of those have caused some challenges that are different for marketing, because those two areas are addressed commonly when it comes to marketing, whether we're talking about cookies or contact forms or other sources of gathering personal information. It seems to me that marketing creates more of a challenge and more of an incentive to stretch the bounds of what's compliant when it comes to consent and legitimate interest. And then the fourth reason is the universal need and participation in marketing. So, the purpose of this webinar was to help organizations that do marketing as a service, but it's also intended to help organizations that do something completely different as a core service. We work with a lot of software providers, and marketing isn't what they do as a company, but marketing is necessary to their organization. And if they're marketing to the EU, then they need to know how GDPR impacts their marketing activities. So that can create even a greater challenge, because there might not be resources or the attention that marketing should get from a compliance perspective. So everybody, there's a wide need for GDPR considerations when it comes to marketing, regardless of whether that's your company's core service or not. All right, now that we've kind of established why marketing warrants its own webinar, the importance, the visibility to complaints, the issues, let's talk about the first topic that can create challenges when it comes to marketing and GDPR. GDPR doesn't take the position that marketing is an absolute universal right, that companies can market to anyone they want to. Instead, GDPR creates the regulatory reality that marketing is permitted with limitations. And those two limitations are: marketing has to be legal. So that's the first hurdle that you have to overcome. And then second, even if it's legal, it still has to be permissible. You might have marketing that at one time was legal, but might no longer be permissible. So if you don't have both of those items covered, then marketing is not permitted. So let's talk about the first of the two primary options that marketing generally uses to address the legality requirement, and that's consent. Consent is one of several different means for establishing a legal basis for marketing to individuals, but it's not required. So I wanted to address a myth when it comes to GDPR and marketing to individuals, and sort of set the facts straight. And that is, GDPR requires someone's consent in order to market to them. And if you're still wondering, why are they still, I heard what he said at the beginning, but I'm still not sure why they need a webinar on this. I still see publications, whether they are directed from marketers to marketers, or from compliance individuals or information security individuals to GDPR compliance, and they're still saying things that indicate or explicitly say that consent is required under GDPR to market to individuals. That's not true. Consent is one option. Now, I need to add a caveat to that myth. Explicit consent is required to use special categories of data to market to individuals. And special categories of data include things like healthcare data and race and union membership and religious information and philosophical information and genetic data. So there are some categories of data that do require explicit consent, but outside of those areas, and I would guess that most marketing wants to avoid those special categories of data. You don't have to have consent in order to market to someone. If an organization does choose consent in order to establish a legal basis for marketing, it is also important to note that consent has to be affirmative, clear, unambiguous consent. So another myth is sort of, I think it's because of the e-privacy directive, which is another regulation in the EU that addresses marketing activities in addition to GDPR. And it's this concept of soft opt-ins, where, for example, if someone provides an email address as part of contract negotiations or for the sale of a good or service, then organizations are permitted under the e-privacy directive to use that email for marketing purpose. But that soft opt-in isn't consent under GDPR. So if the law that applies to your marketing activities is GDPR rather than the e-privacy directive, then the consent that you have to obtain, if that's the consent is the method you're going to use to legally market to someone, that consent has to be, as I said, affirmative, clear, unambiguous consent. And that means the same thing for consent for marketing as it does for consent for any other processing activity. You can't have pre-checked boxes. You can't be partially transparent about the nature of your activity. So if you get consent to use their information for an internal service, but you're also going to share it with a third party for that third party to market to them, that isn't clear. If you're going to use it to market to them multiple different products or services that wouldn't reasonably be connected to the service or product that they're interested in, there's a chance that's not unambiguous or clear. So consent when it comes to marketing is the same as it is for any other processing activity. But I think because of the e-privacy directive and because of the way that U.S. law allows for pre-checked boxes and sort of something similar to a soft opt-in, that there's this misunderstanding that you have consent if the data subject has kind of interacted with you in a limited capacity. It's also important to note that if you use consent as the legal basis for processing data, that data subjects have the right to withdraw that consent at any time. And so if you felt like consent was the most appropriate legal basis, then you do put yourself at risk for having your ability to market to certain individuals taken away at their discretion at some point in the future. All right, now let's talk about legitimate interest now that we've talked a little bit about consent. GDPR balances data subject rights with respect to direct marketing and the downsides to getting consent as a legal basis for direct marketing with a nod towards business interests when it comes to the concept of legitimate interest. So the lawmakers understood that if organizations had to get consent every time they wanted to market to an individual, that would really hamper organizations' ability to market. And also, it would probably not be within the expectation and interests of data subjects. So data subjects don't always feel that they have to have given explicit consent to be marketed to. So for example, if you purchase something from Amazon and they provide you based on their algorithms and their analysis with other products that you might be interested in based on what you just bought, that's generally accepted by consumers as an appropriate use of their information. So there's not even necessarily an objection from a data subject perspective. So as a way of giving data subjects more ownership of their data, but also not unreasonably, at least from a regulatory perspective, hampering business interests, GDPR includes this concept of legitimate interest. While legitimate interest can apply to any particular processing activity, Article 47 of GDPR specifically says that the processing of personal data may be, for direct marketing purposes, may be a legitimate interest. So the law doesn't just give this nod to business interests to market, it explicitly acknowledges that marketing might be a reason that legitimate interest might be a reason to market to individuals. The challenge with legitimate interest is that it's not as clear as consent. It's probably the understatement of the day, but it requires some analysis in order to determine whether or not you have a legitimate interest before you can proceed. And so there's a 3-part test for determining legitimate interest for any activity, including marketing. And that specific, from the law, it says it has to be necessary for the purpose of the legitimate interest pursued by the controller or a third party, except where such interests are overridden by the interests or fundamental rights and freedoms of the data subject, which require protection of personal data, in particular where the data subject is a child. So we have to perform this 3-part test. First, when it comes to the purpose part of the test, you have to ask and be able to answer the question, are you pursuing a legitimate interest? Well, that's not very helpful. We're using some of the terms in the question that we're asking. So more specifically, ask yourself, is the activity legal, ethical, or fair? Under the e-privacy directive or other marketing laws that aren't GDPR, a marketing activity might not be legal. Even if GDPR might otherwise permit it, there might be a specific country law that prevents a certain type of marketing. And so if an activity is legal, then it's not necessary for the purposes of a controller. Another question, a couple of questions to ask under the purpose test are, who benefits from it, from the legitimate interest or supposedly legitimate interest, and what would happen if you couldn't process in the way that you wanted. So what would happen in this case if you couldn't market in the way that you're proposing or thinking about doing? Is there some other way that you could do it? The second question, second part of the test is the necessity test, and that involves asking the question, is the processing necessary for that purpose? Or is there another way that you could accomplish the same goal in a different way? And then an additional question is, does the processing actually accomplish the purpose identified in part 1 of the test? So if you've identified the purpose as to grow your business and marketing is the only way to do it, then you'll probably be able to answer yes to both the purpose test, because growing a business is a legitimate interest, and marketing is necessary to grow that interest. So probably be able to answer yes pretty comfortably to both in both of those cases, unless, of course, as I said, there might be a law or an unethical aspect of that marketing activity. And then we get to the balancing test. This is the third part, and this is where things are going to become more challenging and probably more particular to organizations than the first 2 questions. So in this case, we're asking, do the individual's interests override the legitimate interest of the organization? So whose interests have the most weight in the decision about whether to market to individuals? So in asking and answering that question, some of the things to consider are, what kind of impacts are the marketing activities going to have to an individual? Is there something that's going to impact them in a certain way that's significant? What kind of safeguards are in place to address those impacts? What kind of opt-out options are in place in case the individual decides that their interests should outweigh the organization's interests? What kind of relationship does the organization have with the individual? The greater the relationship, the less likely it is that the individual's interest might override the organization's legitimate interest. And then another one is, what kind of sensitive data is used? And in this case, I'm not even necessarily referring to special categories of data. I'm just referring to data that might be considered sensitive. There are things about employment or maybe age or location that aren't considered special categories of data. Location isn't considered a special category of data, but it might be considered sensitive. And so the more sensitive information is used, then the greater the chance there is that the individual's interests would override the organization's interests. So I've got a graphic here to show you what that balancing test might look like. Just putting these multiple different components on a scale for each different marketing activity. So if it's a different marketing campaign, or if it's a campaign that uses a different technology or targets a different group or a different service, those could all be opportunities to conduct this legitimate interest three-part test. All right, now that we've talked, and just to wrap that part up, if the answer to the three questions is yes to one, yes to two, and no to three, then you have a legitimate interest and you can proceed. If any part of that test fails, then you would potentially be in violation of GDPR if you went ahead and marketed if you didn't have a legitimate interest, or the marketing activity wasn't necessary, there was another way, or if the individual's interests overrode the organization's interests. It doesn't have to be that all three go in favor of the data subject. Just one of those is enough to remove legitimate interest as one option. And then you could always go back to consent or one of the other legal bases for processing as a grounds for marketing. All right, let's talk a little bit now about disclosures, because this is something that has caused an issue. We're going to talk about that in a little bit with organizations that either market or organizations that are serving marketing activities as third parties. The truthfulness and transparency of their disclosures has caused complaints to be filed. So for organizations who are marketing in a way that's subject to GDPR, your privacy policy must be transparent about those marketing activities, specifically about the third parties that are used. And whether you choose to specifically identify those third parties in your privacy policy, or you just simply reference marketing companies or marketing analytics or some other kind of organization that participates in your marketing if you're not doing it directly, or that's supporting your marketing services as a company. You need to be aware that the less specific and the more vague you are, the more likely you are to draw a complaint. So you need to think about how specifically you articulate the third parties that are involved in your marketing activities. Again, whether it's in your privacy policy or if you just reference types of organizations such as analytics and marketing, and then data subjects follow up and ask you for more specifics about that. How particular will you get? Would you name an organization in response to a data subject request? Second, what types of personal information is used in marketing? Are you using names and email addresses? Are you using other pieces of data? And just kind of as an aside, this brings up the concept of data minimization and whether or not the amount of information you have is appropriate for the kind of marketing activity that you engage in. I saw one example in some discussion on GDPR marketing. They said, do you really need to know someone's favorite movie before you market a perfume or a cologne to them? And the answer is probably not, unless there's some kind of tie-in between those products and movies. You probably don't need that information. So just be aware of the amount of information you're collecting, because that information is valuable, but it also subjects you to more regulatory exposure. Just be aware of the amount of information and its connection and necessity to the marketing activities you're engaged in. And then you also need to disclose the legal basis for marketing. So the reason that we talked first about the legal basis for marketing isn't just because it's one of the most important parts of the GDPR considerations, but if you don't know it, you can't disclose it to your data subjects and then allow them to exercise their rights as required by GDPR. So your privacy policy should say that we market to you based on legitimate interests. Or some organizations I've seen get very particular in terms of the type of marketing activities they engage in. They may have multiple different marketing activities and multiple different legal bases for processing for those different marketing activities. So they may have marketing activities in which they're using consent or a contract as their legal basis, and then other marketing activities where they're using legitimate interest. But that should be spelled out in your privacy policy. And if not, you should be able to, and in addition to that, it should always be spelled out in the privacy policy. You should be able to explain that more thoroughly if a data subject asks for more information. So those are some of the just a kind of a high level, but specific items that should be included when you're thinking about your marketing activities, the kind of disclosures that you need in your privacy policy. All right, now let's talk about what data subjects can do with respect to direct marketing. And the answer is they can request a full stop. As I said at the beginning, the right to object to direct marketing is the only data subject right that is connected to a specific processing activity, but it's also a right that is absolute. That means there are no conditions or exceptions like some of the other data subject rights. For example, the right to be forgotten and the right to restriction. Those data subject rights have some considerations about whether or not certain factors are at play and whether or not certain exemptions or exceptions can be met so that an organization can deny the right. But in the case of an objection to direct marketing, you don't have to perform any of that analysis. You simply have to stop. And it appears, based on the numbers that I've been able to find, that data subjects are exercising that right with some frequency and are exercising their ability to complain as required by GDPR. That's something else that should be mentioned in your privacy policy, with greater level of frequency when organizations fail to respond to data subject rights. So just note that if you are engaged in marketing either as your core service or to support your business, that if you get a request to stop, that you should respond immediately and fully, and be aware that if you don't, you're subjecting yourself to one of the most frequent reasons for individuals to exercise their right to complain. A couple ways that you should consider facilitating that right to request cessation of direct marketing is email opt-outs, subscription management tools, sources on websites, email addresses, phone numbers, physical addresses, to be able to contact the data protection officer or the organization to request that the organization stop marketing. All right, now let's talk about some of the ways that GDPR marketing developments have occurred over the past 12 or 13 months. So as I mentioned, that data subjects have been filing complaints about marketing activities in violation of GDPR. But beyond that, it's gotten a little bit more serious in that there is a privacy organization that has filed some formal complaints against some data brokers and even some credit reporting agencies, MasterCard and Experian, the credit card company and the credit reporting agency in relation to the way that they have used data. And that privacy organization has called for an investigation and enforcement actions and has alleged specific non-compliance with GDPR. Specifically with respect to marketing activities, the organization said that certain data brokers who primarily serve marketing companies were obtaining information about data subjects from sources other than the data subjects themselves. So this is an area where we've had conversation with our own clients, and I have seen discussed in different thought pieces about whether or not getting personal information from like publicly available sources is subject to GDPR requirements, and I do believe that it is. And I think this complaint is going to flush that issue out. So just be aware that if you're using data brokers, that there is some potential exposure there. And if you're obtaining information about data subjects for the purposes of marketing from sources like social media or data brokers other than, any source other than the data subject, that there's some potential regulatory exposure there as well. Two issues from the UK's Information Commissioner's Office that highlight the importance of considering your marketing activities when it comes to GDPR. The ICO has made web and cross-device tracking for marketing one of their top regulatory priorities in their most recent regulatory action policy, and that's available online if you want to read it. They identified several priorities, and web and cross-device tracking was one of those priorities. So we've seen a little bit of of outcome from that. The other issue that you see in front of you is the ICO has issued some fines and some warning letters for unsolicited marketing activities. I think they have primarily or exclusively been telemarketing activities, but because we're still within the time period of that regulatory action policy, I suspect that we may see some additional enforcement activity in the future about web and cross-device tracking and some other marketing activities other than telemarketing that reflect the ICO's prioritization. So just know that the ICO to some extent is being consistent with the fact that it's prioritizing marketing activities in the regulatory area by sanctioning organizations. And then the fourth one we're going to discuss, there's a lot more, but the German Data Protection Authority has issued some guidance on marketing activities. The ICO is pretty good about providing guidance, and they've issued some guidance on marketing activities. And we're going to talk a little bit more about things that are coming out from the ICO, but the German Data Protection Authority issued some guidance, and it included some concepts like consumer satisfaction surveys are considered marketing activities. So just be aware that's sort of a state-specific, member state-specific perspective. But if you're doing business in Germany or for German residents or citizens or individuals who are located in Germany, and you're performing consumer satisfaction surveys, they consider that to be a marketing activity. The guidance also includes examples of some generally justifiable and unjustifiable marketing activities. We'll get into those in a little bit. And then it includes some discussion about permissibility when it comes to channels of marketing, like email, phone calls, text, mail, and different aspects to think through when you're talking about the marketing channel itself. So be aware that there's additional guidance, again, that's from Germany, so that's not necessarily universal, but it could help provide some clarity around some of the concepts that GDPR seems to have left so vague and difficult to understand. All right, now let's talk about some specifics, some situations that have come up when it comes to marketing, specific marketing activities and how they are impacted by GDPR. So the first one is, kind of the concept of referring a friend. So you've got someone providing you with their personal data, and you're asking them to provide a friend's or someone else's personal data, maybe in exchange for a discount or some other kind of promotion. It should be noted that the German guidance that I just referenced said that this kind of approach is difficult to justify as a permitted marketing activity because it's not really fair and transparent. The friend doesn't have insight into the exchange of information. So just be aware that if you use that refer a friend approach, the German Data Protection Authority might find that difficult to justify as a permissible marketing activity. The second one is loyalty programs. And my background is as an attorney, not as a marketing executive or analyst or developer of marketing schemes, but I do understand that loyalty programs are a rich data gathering tool. And we're talking about creating incentives and marketing schemes for frequent and or high value customers. One of the questions that arose is legitimate interest a permissible legal basis for marketing under the loyalty program? So specifically, if I'm a frequent shopper of a certain website and they have a loyalty program, the fact that I purchase items from that website, but I haven't explicitly said anything about the loyalty program, can that organization use legitimate interest as a legal grounds for sending me information about their loyalty program? And the ICO says that consent or legitimate interest may be appropriate reasons, legal grounds for marketing loyalty programs to customers. So you've got options there. The third example is business to business marketing. Again, this is an area kind of like can we grab information about data subjects from third-party sources, even if it's especially publicly available sources, that doesn't really come under GDPR's coverage, does it? And the answer is business-to-business marketing and gathering information from a third-party source both are covered by GDPR. And generally the same considerations for business-to-business marketing come into play as marketing from business to consumer. So lawful basis, notice, and data subject rights. Just because the email that you got from an individual is their professional company email, it doesn't render it outside of the GDPR considerations. And then a fourth consideration is some third-party content. I just talked about, using third-party sources to get information, particularly when it comes to profile creation, but also sharing with third parties for the purposes of those third parties marketing to data subjects. In the German guidance, there is a presumption against both of those. So both the German Protection Authority considers creating a profile based on information obtained from a third party and sharing information with third parties for the purposes of those third parties marketing as difficult to justify. One way to make it more likely to be permitted is to establish, especially on the sharing with third parties for their marketing purposes, is to establish whether there's a relationship between the data subject and the third party. So I think that's still going to be tricky, and that presumption is probably still worth considering. But if there is a relationship between the data subject and the third party that you're sharing with, there is a reduction to some degree of the compliance exposure there. All right, so let's wrap it up. The things to take away from this presentation, I have identified the legal basis, but really what I think is most important is to understand the legal basis. Again, dealing with the myth or the commonly circulated perspective that explicit consent is required to market is incorrect, or that soft consent complies with GDPR. Both of those are sort of in tension with each other, but they're both incorrect. Consent isn't always required for marketing, but if you do get consent, you have to have that clear, affirmative, unambiguous consent. So it's important to understand the legal basis because it impacts things like data subject rights and the way that you respond to them and the way that data subjects exercise them and the kinds of information that you can use. Again, going back to that requirement to have explicit consent to market using special categories of data. So it's not just trying to check off a box, it's really understanding the concepts and being able to engage in the balancing and purpose and necessity test under legitimate interests in a way that allows you to approach new marketing opportunities and new data subjects in a way that's going to reduce your potential exposure. Second, review your privacy policy. If it doesn't describe third parties, if it doesn't include the legal basis for processing, and if it doesn't include information about the kinds of personal information used in marketing activities, then it needs to be revised and revised quickly. Your privacy policy is a very public part of your organization's GDPR compliance and other privacy regulation and oversight. So just be aware that that's something you're putting out there and people can easily access. So that's something that should get some attention to make sure that it's accurate and up to date. Don't mess around with data subject requests. Again, these data subject requests draw attention to yourself. So someone may either be frustrated or be in the potential to be frustrated with the way they're using their data, especially if it comes to marketing. And that's evidenced by the fact that data subjects are complaining about telemarketing and promotional emails. One of the things that we found out a year into GDPR is that organizations are either failing to respond to today's subject requests or they're responding in an untimely fashion. If you do that, you're just creating an additional layer of compliance risk. So, if they ask you to stop direct marketing, there's compliance risk there if you fail to do that. And then if you fail to respond to their request to do that, you've just added another potential area for complaint and potential sanctions and fines. So don't mess around with those. If someone asks you to stop, if someone tries to exercise the unsubscribe options they have, make sure it functions and functions in a timely manner, so you don't create unnecessary compliance risk for your organization. And then fourth, monitor guidance and member state publications. In addition to the guidance the ICO has out there and that the German Data Protection Authority that I referenced, the ICO has said that it is working on a code of conduct for marketing that will provide more clarity regarding compliant marketing practices. So that could potentially be the very first code of conduct, official Data Protection Authority published code of conduct that we get for GDPR. That would be a pretty big deal. So it's worth it to monitor what's going on, whether you have a resource internally or you can find free resources or you have outside counsel or consultants that can help you stay on top of what's going on so that you don't miss an opportunity to correct behavior that may have been unclear. You may have had a reasonable position to think that your marketing activities are compliant, and then all of a sudden the German Protection Authority comes out and says, that there's a presumption against using third-party sources to create a profile. Many people did think that was permitted, and now there's reasons to think that it's not. So it's worth it to monitor what's going on with states to give yourself some additional resources to try to comply with GDPR. All right, that is the conclusion of our presentation today. So we're going to open it up to see if there's any questions. And while we're opening it up, just to let you know, if you have more questions about your GDPR compliance efforts, including your marketing activities, we want to offer our services to you. We are an information security firm with data privacy services. We have the people and the processes and the tools to be able to address both security and privacy simultaneously. And we have the ability to provide those services for global and custom privacy requirements.
Great. Thank you so much, Mark. Yeah, keep sending in your questions. We've got a couple here to start out with. Let me pop this up really quick. How does GDPR define direct marketing? You covered this a little bit. And would it apply to social media campaigns or targeted display ads?
That's a good question. I think that there is a difference between that concept of direct marketing and the ability for an individual to say, stop sending me an email, and things like social media engagements. There's probably a spectrum where on the one end you have just general social media activities, and then you have more targeted activities. I would err on the conservative side, given the friction, to say that if an individual complains, to the extent that you can, you stop, even if the activity might be on the border of direct or more general marketing activities. But things like a targeted phone call or email or text or traditional mail activity would fall under the concept of direct marketing activities.
Gotcha. Another question, in the right to be forgotten with GDPR, how do you handle purging things like email addresses and mailing addresses from offline backups, or is that even necessary?
So that's a good question. And there's still some discussion about that and a lack of real clarity. Most practitioners say that it's not feasible or secure or safe or reasonable to address backups, and so that they don't have to be addressed. And it's important also to note that the request to stop direct marketing isn't the same as the request to be forgotten. And I'm not assuming that the person who asked that question thought that, but just to note, that's one of the things that's different about the objection to direct marketing, is that doesn't mean you have to delete their information. It just means you have to stop targeting them as a data subject. So you could still potentially maintain their email account, because you might have other reasons to use their email. So for example, if you are marketing them, but you also have a contract with them for something else, that contract is still at play. Or there might be legitimate business interests in maintaining their email address related to security or legal requirements or other things beyond the marketing relationship that allow you to maintain backup information.
We've had a lot of webinars in the past about if GDPR applies to you and what your role is. We're getting a couple of questions about how GDPR affects companies in America, whether it's a marketing agency itself or just a marketing department. So, Mark, do you want to give a quick answer to how does this all affect American companies?
Sure. So GDPR is not a marketing law, but it does apply to, potentially applies to marketing activities. So there are several ways in which the law references its international jurisdiction. It does assert international jurisdiction. So even if you are in the somewhere outside of the EU, including in America, there's the potential that GDPR applies to you. And so it uses terms like offering goods or services to those who are in the EU. So, there's a couple of ways that we can give specific examples to maybe help explain what that would look like and whether GDPR would apply to you. If you have a website and it's in English and the currency that you sell your good or service is American dollars or Canadian dollars or some non-EU currency, and there's no particular aspect of your website that is targeting one or more EU member languages or countries or cultures, it's just a website that's available to somebody from the EU, then you might not be considered, that information might not be required to be subject to GDPR. On the other hand, if you sold a good or service and you had a website that was designed for American or Canadian or South American consumers, and then you had a different version or multiple different versions of that website that were targeted at French and or German or Italian or Spanish individuals, the fact that you're actively targeting them by using their language, currency, if you were to send information physically to the EU or to email addresses in the EU, those would be all ways in which you'd probably be considered to be under GDPR because you're actually offering goods or services or monitoring the behavior of those in the EU. Does that make sense, Jenna?
Yes, that was a great overview. We could go on about that for hours.
Yeah, so it's basically a spectrum of, sorry, Jenna, just one last point. It's basically a spectrum of, did you happen to have interaction with someone from the EU just because they somehow stumbled upon your website or your information, versus were you trying to actively engage through offering goods or services or monitoring the behavior of someone that's in the EU? The more you target, the more likely you are to be subject to GDPR. And now I'll stop.
That's perfect. I know we have a lot of participants today who are not directly a part of their marketing team. Primarily a lot of IT people on today. So how do you recommend, if you're someone in an IT position, how do you get that buy-in from your marketing team to look at GDPR or pay attention to it?
That's a good question, because even though GDPR is not technically a information security law, in our experience, most of the individuals who are tasked with GDPR compliance are housed in information technology or information security groups. And so we have seen some disconnect between GDPR compliance efforts where the individuals who have sought out on their own, or they sought out third parties like ourselves to help them with GDPR compliance, are addressing things like application development and software, internal and consumer facing, to address GDPR, but the marketing group kind of is on its own. So I think you have to get buy-in from the top. So maybe you've got a really good relationship with somebody in marketing, and then in that case, maybe that's the way to do it, is leverage that relationship. But if not, I think I would say this isn't a marketing versus IT discussion. This is an entire company need, and so it should come from someone who has the ability to encourage marketing to understand that's the perspective, that this isn't just an IT requirement that's being communicated, parallel or underneath. This is something that's coming down from the top that the whole company has to address. And marketing is just one of those areas in addition to IT. So my first suggestion would be go to someone who can speak authoritatively to marketing and say, this is important. And then second would be to offer assistance to the extent you can, to say, I'm not just telling you what to do. I can help you to the extent I know how, or have resources that I can point them to, like this webinar or other sources. We can help you. We have some things to do. Look at your privacy policy. Let's talk through whether we know the way that our legal basis. Do we have any resources to help us with member state specific things or codes of conduct? Those would be the ways another way to help is, in addition to giving that authoritative voice, is offer some specific assistance so that they're not left on their own, especially if they didn't initiate the compliance activities.
Gotcha. I think that'll be helpful to a lot of people on here today. What are maybe one or two of the most major kind of changes that you've seen marketing teams having to make in terms of GDPR?
The cookie consent and the consent process is an area I still think is woefully under addressed. I still personally and professionally use websites that have those statements that say your use of this website means you consent to the following. And that may work for non-GDPR requirements. It may not even work for some of those, but it doesn't work for GDPR. So if your organization is using cookie disclosures, or maybe doesn't even have one, but is using cookies or other consent activities, that would be something that I would consider. The other thing that organizations may need to do a little better job of, going back to that German guidance that said that consumer satisfaction surveys are marketing activities, is to evaluate just what is considered marketing. So, for example, our organization, Jenna, we send out consumer satisfaction surveys, and I'm not sure that we would have thought of those as strict marketing activities. Those are provided to clients already after they've completed an engagement with us. So that might, from a surface level, reasonable perspective, feel like that's not a marketing activity, but that's a product development tool or quality assurance tool or something like that. So organizations should say, what are we actually doing when we interact with our customers or potential customers that might actually be marketing, and we didn't think of it that way.
Gotcha. Well, that was our last question. Thank you so much, Mark, for this really informative presentation. We're getting a lot of feedback from you guys that this is a good overview, and we're happy to give it. If you have any more questions, Mark's email is on the screen right now, and you've got mine. Please don't hesitate to send any questions that you have. And as another reminder, you will get a copy of this presentation tomorrow, an on-demand kind of link and the PowerPoint. So please feel free to pass it along to any of your colleagues. I know this is a subject that might need multiple people involved. So please feel free to pass it on and let us know if you have any more questions. Thanks so much, Mark, and everyone have a great day.